He's on the email, but I sent it to him.
We have a motion on the table and a second to approve the transfer of ownership for permit 341. All in favor say aye.
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 Okay, y'all are about to be really annoyed with me. Were we on mute that whole time? Can we do that all again? Yeah, can we do that all again, not on mute? Sorry,
Yeah.
guys, growing pains with the new room. Apologies.
Okay, let's, are we off mute now? Okay. Let's do transfer of ownership permit 272.
There is one owner leaving, the others are absorbing that. There was nothing really for ABC to vet. We found no problems.
I requested additional documentation and recommend continuing until January.
Second.
We have a motion on the table and a second to continue permit 272. All in favor say aye.
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 Next, we have permit 329, Dark Horse Medicinals. There's an existing owner we previously vetted. ABC found no issues.
Based on my review of the documents provided, no issues.
Commissioners, questions, comments?
I'll make the motion to approve 329 transfer ownership.
Second.
We have a motion on the table and a second to approve the transfer of ownership for permit 329. All in favor say aye.
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 Next item is permit 341.
That's correct. We have the collective. There's an existing owner who's been previously vetted. ABC found no issues.
Based on my review of documents provided, no issues.
Move to approve 341 transfer.
I'll second the approval.
We have a motion on the table and a second to approve the transfer of ownership for permit 341. All in favor say aye. Aye.
Aye.
Thank you, everyone.
Okay.
Next on the agenda for today, we do have the management contract rules. This is the public hearing for public comment. These obviously we've received one written comment from Miss Erica G. with Wright Lindsay Jennings. I believe we also have at least a couple people signed up to speak in person today. So, commissioners, I will let you guys set a time limit if you deem necessary. I don't think we have too many people here today, so it shouldn't be an issue.
We don't have that many, so I don't think that we need a time limit. Well, who's first on the? Okay. All right, can y'all identify yourself for the record?
Yes, I'm Bill Pascal. I'm here as the Executive Director of the Arkansas Cannabis Industry Association.
Erica G. from Wright Lindsay and Jennings, here to represent the Industry Association.
Okay.
Thank you for giving us time to speak today. We had ACI treasure our relationship with you and the staff, and I want you to know that we want to work with you and try to find solutions for the industry and for the patients of Arkansas. I'm going to be brief today and give you a big picture view of why we oppose this proposed rule, and then I'm going to turn it over to my legal counsel here to go into the specifics of the rule. First of all, we think this rule is an answer searching for a problem, and we think it's a bad answer. And Erica will go into more detail about that when she goes through the rule. To my knowledge, today, there are no out-of-state management contracts in existence. Now, when the industry cranked up in 2018, 2019, we had folks that had won license here in Arkansas that didn't have expertise. And that's not unusual. That happens in most startup states. So what they do, they turned to some out-of-state consultants, entered into some management contracts to help them get up and running, to get the experience and the expertise they needed. Well, today we are up and running. As you guys all know, we have thousands of people employed in the industry. We generate over $30 million a year in tax revenue to the state. So up and running. The Arkansans that won those licenses early on have acquired expertise. They've learned to run their dispensaries and the cultivation facilities without the out-of-state management folks, and we don't have any today. So the era of out-of-state management contracts is over, and so we don't really see the need in this rule. And with that in mind, I respectfully ask that you guys not move forward with the rule as written.
Okay.
Good afternoon, everyone. As you mentioned, Director Bjornson, we submitted a written comment on behalf of the industry, and I just wanted to highlight a few things in that written comment in our oral comments here today. As Bill was pointing out, this set of rules creates a structure that is problematic, and it's problematic in several respects. But I think that we need to spend a little bit of time talking about how it creates some unintended consequences. I believe unintended consequences in the way that the industry will have to operate once these rules go into place. And I think that the effect that will have on the actual operation of the industry, as well as the operation of this commission, deserves some closer scrutiny. So beginning with that, there were some changes in this revision, and I appreciate the effort to make some revisions to this. But the definitions of management company and management contract are still very, very broad. And in order to be compliant, I think most licensees are going to be forced to consider many, many different kinds of contracts to potentially be a management contract, because it's defined so broadly. Everything from the guy who does your lawn service to your attorney to your IT to all kinds of things that could potentially be considered a management contract. And under these rules would need to be submitted to you for approval before they could go into effect, and would need to be submitted to you for approval before they could be revised. In addition to that, the commission is tasked with determining whether the contract terms are commercially reasonable, which is also very, very broad. Furthers a legitimate business purpose and is sensible considering the characteristics of the parties. I think that puts a very large burden on you to make the decision about whether any particular contract meets that definition. But in addition, just from the standpoint of business people, it's very hard to operate a business when you don't know whether your contract is going to be accepted, and that can't go into effect until it is accepted. So that just introduces a level of uncertainty as well as a delay that from an operational perspective will be very difficult. And I don't know if anyone has calculated or estimated the number of contracts that are going to be coming in front of you under these rules, but it's going to be substantial, very substantial number of contracts, because these are big operations. They have all kinds of business relationships. And if it's determined to be as broadly defined as it is right now, you're going to be seeing a lot. In addition to that, we think that the requirement that a contract be commercially reasonable is unnecessary. Businesses determine what terms make sense for their business relationship every day, and the government is not involved in that. And there's not any reason for it to be involved in that here. In addition to that, there's nothing in Amendment 98 that would give you the authority to make that decision, which would render these rules unconstitutional. In addition to that, the process that's set up here, that is what I've been talking about, but then there's also specific provisions about what have to be included in all management contracts. And again, that's defined very broadly. It must include the ability for either party to terminate the contract with reasonable notice. I'm sure those of you who have been involved in business transactions can imagine that there are a lot of circumstances where the other party is not going to like that term, is not going to like the idea that they have to allow the contract to be terminated with notice, without penalty. In addition to that, it requires the contract to include a term where the parties can renegotiate the contract at any time. Or I'm sorry, an opportunity for the parties to renegotiate the contract. Both of these aspects are very intrusive in terms of the way that businesses operate and the way that they negotiate terms with someone that they're operating with. And once again, the commission lacks the authority under Amendment 98 to dictate those terms to the parties. Finally, I think that, and this is going to build on a little bit about what Bill said, I think that this is a problem that no longer exists in the state. But to the extent that you want to make sure it never again exists in the future, I think there's other ways to go about it. Other ways to approach the concept of out-of-state interests operating in the state that are not so intrusive, that do not create a regulatory scheme that would be so burdensome on all the licensees, on the commission, on ABC staff, and ultimately on the patients, because it's going to interfere with the operations of the industry. Thank you very much.
Commissioners, you have questions? For them? I've got a few, but I'm wait for y'all. Got a question for council. Is there a question if it's constitutional or not? I mean, from your standpoint?
I wouldn't comment on that.
Okay. Because if it's the way I look at it, if it's unconstitutional, why, you know, go through years of lawsuits on it? But that's.
If I could interject on that one.
Sure.
There have been previous versions of this same type of rule, previous draft. In between the previous draft and this time, we did receive public comments the first time we did it. And we also worked with the AG's office, which was other counsel at the time, and they had input on this draft. So I think the AG's office would have flagged to us before today if they saw a constitutionality issue.
Okay. Do you guys have any questions?
I'm a little confused. Excuse me, I'm the new guy here.
Here, speak
And
closer.
You said there were problems with the renegotiation provision. It's been a long time since I took contracts, but I thought we could renegotiate a contract at any time anyway.
That depends on the contract. That would be a term of the contract. There are certainly many contracts where you can't terminate it early and you can't renegotiate it.
If
And
you
that's
can,
one
you
of
can
the
put
terms.
that in there, but there's nothing to stop me from coming up to you and saying, hey, let's redo this contract anyway.
Well, that's true. And if I agreed to do that, then I would be agreeing to. But a requirement that you must be able to do that is a step beyond.
Okay.
Okay, we're talking about, I'll go say any other commissioners. Go ahead. We're talking about commercial reasonable. Are there any other states that use that term? Or will we be the only one?
The term commercially reasonable is a legal term of art
Right.
that's used about contracts. I'm not aware of any other state agencies that make a determination about whether a contract is commercially reasonable.
I was talking about the marijuana industry and other.
I'm not aware of that either.
Okay. Is this like if we were to pass this rule, does it need to be legislative or does it need to be through here?
Well, I think our position would be that this goes beyond the authority that the
That we
commission
have.
currently has.
Okay. Okay. Do you know of anything in the industry that, or anywhere in industry where, you remember several years ago, we had somebody that had signed a contract, they couldn't sell, they weren't receiving anything, were just paying taxes. Do you know of anybody else in industry that has that same issue, or is that,
I don't know.
or did industry correct itself?
Corrected itself.
Okay.
It's a natural evolution of an industry. When you have a startup state, it's the natural evolution of the industry. When you have a startup state, people that win the license, especially if it's geared towards licensees being residents, they generally don't have the expertise and experience, so they'll go out and get that from out of state. And over time, as they acquire that experience and expertise, they wean themselves off of that out-of-state management contract model. And that's what's happened here. And Arkansans are now in control of their operations, and they're not reliant on those out-of-state management companies.
Well, let me ask you this.
Yes, sir.
I heard you say that and I understand, but is there anything to stop an out-of-state management company from coming in?
Only the good sense of most Arkansans who own these things.
Well, you have a lot more faith than I do in a lot of people, but congratulations.
You guys have helped weed out the bad ones already.
Yeah, okay.
That's all the questions I had for y'all. Who's next on the?
Do we have anyone else here who has not signed up who would wish to make a public comment today? Okay,
I do have one more.
sure.
I know y'all probably have. Is it on now? Okay. I know y'all probably have semi-annual or annual meetings with a group, and I know y'all discuss this. What is on your side of it? What are y'all looking for? I mean, are we talking about just tossing out all, everything, or do you have some kind of comeback of what
No, I
would
think
be a reasonable, don't want to use that word, obviously. But do you have some kind of idea of what would work good for the industry? And, I mean, obviously we're not here to put everybody out of business.
Right.
And,
we understand that.
and, I guess what I'm asking is, what are you leaning to? I mean, what do you see that we could work together? I mean, if, I know y'all been working together with, staff and all that, but for us to, us to hear it, I guess
So
if you could do it briefly.
So Commissioner Case, we don't really understand the impetus behind this, given that we don't have out-of-state management contracts now. There has been talk in the legislature, and we hear it on the second floor, that there's concerns about foreign ownership. And I know there's been concerns about foreign ownership in California. And if that is what's really driving this, if that's where we're trying to get to, we don't have any problem with you as a commission or the legislature passing a rule or a law that bans foreign ownership or keeps the foreign owners out of the industry in Arkansas. We don't have any, to my knowledge, in Arkansas. And if that's really what's behind this and driving this, we're open to that. We'd love to work with you on it. But as this is currently drafted, we think what's drafted is onerous for our industry, and we just don't really see the need. We've evolved to a point where there are no out-of-state management contracts.
Okay, thank you.
Commissioners, any other questions?
Well, I don't know if this is the proper time to ask this question, but as I say, I'm new, and I'm trying to figure out if these rules were drafted with certain goals in terms of drafting in mind. Were they meant to be fair to everybody, every entity, or it seems to me like in some places they favor the incumbent, so to speak.
So I can give some background. Like I mentioned briefly, there was a previous draft. I think these drafts were initiated somewhere in 2023, early 2024. And to Mr. Pascal's point, a lot has changed in the industry since then. But these rules were drafted to be equally fair to everyone, to provide transparency to the commission about where ownership lies, and to make sure that individuals who were the name on the license were not just a name on a piece of paper, but actually had some control and legitimate business interest in the dispensary or cultivation site of which they owned. So it was to address a specific problem with out-of-state companies coming in and running Arkansas businesses. Again, to the point, a lot has changed, but we welcomed on our original draft and still welcome comments from the industry. This is not meant to create any undue burden. And I do think that our industry partners work well with us in general. They're not shy when they see issues for sure, but I think we're not shy in bringing those up to you guys as well. So just to provide a little bit of background, that was the initial thought behind these rules. And it has taken well over a year to get to this point in the second draft.
Well, for instance, there's one, I don't know why this bothers me so much, but there's a few words in here that I just don't quite understand why they're here. Under your definition of commercially reasonable, you say that is sensible considering the characteristics of the parties. Considering the characteristics of the parties, is a problem to me. I don't know why, but exactly. I'm having a hard time describing it. But if all you take into account is the characteristics of the two individuals or two parties, and not the overall good of the state, that seems to favor the incumbents, as I said.
My mic on. I certainly appreciate any commentary that any of our commissioners may have too. And what I might suggest today, not to tell you guys what to do, but you have options here. You can vote that you don't want this. You can vote that you maybe want to review some of the public comments, review the rules, think about it, vote on it in January. I don't know, there's probably other options I can't necessarily think of right now. You guys can discuss further, if any commissioners have questions about the comment you just made in language that they might like to see added. Really, what you guys tell me you want to see is going to drive what this draft looks like.
Yeah. Do we have anybody else signed up to speak?
I don't believe so. Last call, anyone here to speak?
Commissioner Miller, one of the reasons you don't, the members of the ACIA asked Eric and I to speak on as a unified voice for all of our members. And we didn't want to flood you guys with 10 or 12 folks today. So we're here speaking on behalf of the industry.
Thank you. Okay, commissioners, do you have any questions, comments? This is kind of what I'm thinking. I think that we think about it, go back and read through the comments and everything from today and what was submitted to us, and look at it in January is what I'm thinking.
And if I can interject again, we want to be helpful in any way. So if that is a summary explaining, the first draft and the first comments versus where we're at now and the new comments, whatever you guys might need from us in the meantime to help it be digested easily, let us know.
Okay.
I guess one thing I would like to see in this comment period, and Erica hit on a lot of them, and I'd like to see more like 4 or 5 bullet points of really where you guys are heading. I mean, I know you put in your email a lot of it, but if some of this language, let's point it out and shoot it back to us. This language bothers us, I mean, because I know I can I've read them all day. I had to call Chip about a question about, I couldn't find something. I found it. And I'm still kind of lost on a couple of it. So yes, I would like a little bit more time to.
And one thing I'd like to get cleared up, Jesse, could y'all look and double check the constitutionality of it?
Yes, sir.
Okay. I mean, that's one thing that I want to look at before the next meeting, but I'll go ahead and do it. I want to make a motion to go ahead.
May I make one further
Sure.
comment? I do agree with you, Erica, that the listing of the types of contracts that would be included seems to be like micromanagement. And I don't know if that's what we want to do. Maybe it is. I don't know. But that's just my comment.
So if I don't know if you're gonna say like just not table it until next meeting, but continue, like what happens if we do complete almost overhaul of it? Like, I mean, do we just need to like scrap it, like vote them down or?
You guys could vote to start over. I mean, you could say we don't like anything from this draft, or we can, in the meantime, incorporate commentary that's been made today. If you want us to have a new draft for your consideration in January, we can, but I think we should really continue like discussing this one and if you guys like it at all, or what level of edits, if any, you would like to see. I think would probably drive that conversation. And
Does that help you?
if you have something you'd like to speak of right now, or if we just want to have January kind of be a discussion. So that way, following the January meeting, we know if we're starting over, scrapping completely and not starting over, editing with something different. That way we can that will give you all time so that you're not right now having to come up with every question you may or may not have. So between now and January, I would say list out any questions, concerns, recommended edits. We'll have a report from the AG's office on constitutionality, and then a discussion about where we want to go from here, if that makes sense.
How do you need to get those to you, email them or email them to Chip or?
Just bring them to the January meeting, I think.
I guess.
I know the public meeting.
Yes, public meeting. So I would bring any of your proposed edits or questions to the January meeting and maybe expect a meeting with a little more time.
We won't have time to bring.
I don't think we necessarily have to.
That's what I was more or less asking, like, would
Do
it
you
start
guys-
the process over or can we just revise it?
We can do both. My point is,
Timelines, what I was kind of,
even if it's minor revisions, we have to go through the process of getting executive approval.
And therefore they won't be approved on January. But so
Yeah.
January, we
Yeah.
would just be saying, so this public comment period has ended today. And so this draft, we either submit to BLR and we say we like it, we're going forward, or we do not submit it and we keep discussing. So when we have a new draft, we would open a new public comment
At that
period.
point.
That would be
Yeah,
after
yeah.
January when we decide where we're headed.
Is there a reason we wanted it done by January? Or I think we were doing that for the, I think we were doing that in case we issue new licenses while we were looking at the rules to be done by January, correct?
Yeah, there's no hard and fast timeline on this. We want to get it right. I think
Yeah.
Brandon was just saying if you guys were thinking that this was like opening a new public comment period today for new comments, it's not. This is
Okay, I got you.
correct.
I
I
got
just
you.
didn't know how it would mess up the timeline or change it, but that's more or less what I was getting at.
So you're basically saying any edits will kind of throw it out.
It starts the clock again.
Correct.
Okay.
And Mr. Chambers, just to your point, because I can't help myself, the contracts are not meant to be, it's not meant to relate to everything such as lawn care. It is to the contracts that are instrumental in the sale of marijuana and the business of the facility. So of course, not all lawyers are going to agree on exactly what that might be. And I would agree there's some subjectivity there as far as which contracts, but certainly not meant to be micromanaging.
Yeah, I mean, do we really want to be involved in hiring and firing employees? I mean,
That's something to consider now.
Maybe
under
we do, but-
definitions, possibly, I mean, and or make them less ambiguous.
Okay, so I'll make a motion that we think about it over the holidays, check on the constitutionality of it, and we'll look, see if we have any edits for January.
I'll second that.
We have a motion on the table and a second. All in favor, say aye.
Aye.
Aye. All right. Next item on the agenda is administrative matters.
I don't have anything. Welcome to the new room. This is where we will be going forward. Hopefully we will get technology and everything figured out, but as far as we know, this technology is supposed to be easier for everybody to kind of log on to, so you guys won't have to worry about GoTo links or anything like that. Does anyone not have access to Teams as far as commissioners? Okay, so if you guys need to appear virtually, then it would be a Teams meeting invite. Other than that, I don't think I have anything for administrative matters. We need to set next meetings. Do you have anything?
Yeah, I think I was looking at the calendar. We said January 8th at 2 o'clock and February 5th at 2 o'clock.
I know that
March 5th at 2 o'clock.
I know that the industry appreciates it when we give them as much heads up as possible. However, the other thing to consider, myself and the staff do not appreciate it when we have to like finagle a public comment, when you have to have 30 days between like Thursday meetings, when the ad runs on Friday and you got to get it to the Democrat Gazette by Wednesday. So just keep that in mind. If you set out to March and we do end up having some sort of public comment, we may change that date so that way we're not having to squeeze something in where it doesn't fit.
Okay, that's fine. There was one thing that I did want to bring up. Do we have an update on Texarkana, on the one that was the dispensary that was shut down?
I do not have an update, but some
Do
people
we have
here might.
somebody here? And the reason I'm bringing this up is that we have 6 zones that have 5 dispensaries in those zones, and we have 2 that have 3. Zone 6 has 3, Zone 8 has 3. And I know that one was shut down for renovation or something like that, and I was just wanting to get an update on it.
Thank you, Mr. Chairman. Nate Steele with Good Day Farm and Good 7 Management. Both of those dispensaries are under Good 7 Management. I can give you several reasons why we haven't reopened that location. There have been some issues with that facility in particular. There are some recurring roof leaks, some floor issues, and some internal and external plumbing issues. The roof leaks are especially problematic because of the security camera requirements. Obviously, that puts a lot of security equipment at risk. So the manager and the owners of that dispensary have been looking at other potential locations, both within Texarkana and outside of Texarkana. I would just note, I know you guys are considering the possibility of promulgating relocation rules, which I think would be helpful in terms of whether or not and how we could relocate that dispensary. But if not, obviously we'll just proceed under the current regime. But I would just note for the commission that there are, I think, little over 800 patients in Texarkana. They are being served by the current dispensary. Prices today are actually lower at that dispensary than they were when both stores were open. So I don't think the patients have been prejudiced in any way by that store being closed. But we're kind of awaiting guidance on what happens with the relocation rules, as well as with the rules pertaining to the remaining licenses that haven't been issued yet. I know that one of the applicants that was kind of on the list there was located in Texarkana. I don't think that there's enough patient population to require 3 dispensaries in Texarkana. So we'd kind of like to see how that works out and whether or not there is those licenses are issued, and if they are issued, if one lands in Texarkana, that would obviously inform our decision on where to relocate that dispensary. And in the meantime, I know there's been a question of why not just open it and operate it, in a minor way. And that obviously, kind of going back to what you were talking about with management company rules, even if a dispensary is profitable under IRS Rule 280E, the owners of that dispensary could still end up with, more tax owing than what they receive in profit because of the way these businesses are taxed. And so it's not fair to the licensees and the owners to operate a dispensary even at a profit if the tax distributions wouldn't cover the tax burden, if that makes sense. So that's one of the issues that we face with any store like that just doesn't have the demand, to sustain it. So I'm hoping that that we can wait and see what happens with the relocation rules and with the issuances of those final dispensaries, and then make a decision about where to relocate the dispensary. Obviously, we want to operate it. It's just a question of where and how, and get more guidance on how to do that in the meantime. And of course, I would note, I think you guys already know, there's currently no rule requiring an operation of a dispensary license. If you do that, if you issue that rule, obviously we'll comply with it. But in the meantime, we'd rather kind of see what happens with these remaining issues. But I'm happy to answer any more questions you may have.
Commissioner, any questions?
About 6 months, maybe. I think maybe 6 months, a little over, maybe. It's not far from the one that is operational. So.
And not to get too far off the tracks, but just to remind the commissioners, we did have an open forum regarding transfer of location rules, and the industry representatives were, for lack of a better term, kind of all over the place on what they wanted to see happen. I don't know if you guys remember that. It was some discussion about ABC rules, some discussion of a rebuttable presumption, until you guys direct us that you want to see something specific. We're not currently working on drafting on those. There's always an idea and recommendations from the industry, but I did not find that there was a specific path forward following that discussion that we should be exploring.
Okay.
It is always on the table, though, of course.
Well,
Commissioners, any other questions? Seeing none, that's all I had.
I'm happy to come back and give an update on status anytime you guys would like to know how it's going and that process. Thank you.
Thank you. Director, do we have any other?
No, if you want to set March, you can. Just know that we may ask for it to be moved because of a public comment period. But again, I leave that up to you guys.
You want to go ahead and set it for March 5th, and then
It's up to y'all. We do want to try to schedule in advance as much as possible because we are now in a shared space. ABC uses this room, ATC, Tax Commission, seminars, all kind of other people use this room. So the admin staff would really appreciate it if we could at least save our spot on the calendar. However, there are other options we can still always go to if there's a huge conflict.
I said we go ahead and set it for March 5th. Is that good with everybody? 2 o'clock?
Well, if we're gonna need more time, would we be better off to maybe postpone it a week or something to March?
Well, we don't know yet until January.
Okay.
But what she was saying, let's go ahead and set it so we can reserve the room.
But if we do decide that we're starting over on a different draft and we have to do a public comment, we'll address that at the January or February meeting and keep you guys apprised.
Yeah.
All right.
Any questions or concerns from commissioners? Anything you need to see from staff? We can work on summaries if you need for the next meeting, but really, I would say if you guys just kind of come prepared with questions, we'll do our best to be ready to field them.
Okay, seeing that's everything. Seeing nothing else, meeting's adjourned. Hey, Trent.